described in overlapping and painful detail Sondland's conversation with President Trump on September 7th, Ambassador Sondland submitted an addendum to his deposition testimony, which in relevant parts said this. Finally, as of this writing, I cannot specifically recall if I had one or two phone calls with President Trump in the September 6 to 9 timeframe. Despite repeated requests to the White House and the State Department, I have not been granted access to all of the phone records, and I would like to review those phone records along with any other notes and other documents that may exist to determine if I can provide a more complete testimony to assist Congress. However, although I have no specific recollection of phone calls during this period with Mr. Taylor, Ambassador Taylor, Mr. Morrison, I have no reason to question the substance of their recollection about my September 1 conversation with Mr. Yermak. During his public testimony, Ambassador Sondland purported to remember more of this conversation with President Trump. Although he still couldn't, or maintained he couldn't remember if it was on September 7th or September 9th. And according to his testimony, President Trump did not specifically say there was a quid pro quo. But when Sondland simply asked the President what he wanted from Ukraine, President Trump immediately brought up a quid pro quo. According to Sondland, President Trump said, I want nothing, I want no quid pro quo, I want Zelensky to do the right thing. And I said, what does that mean? And he said, I want him to do what he ran on. In his subsequent testimony, Ambassador Sondland explained that President Trump's reference to what he ran on was a nod to rooting out corruption. Here, however, corruption like Burisma has become code for the investigations that President Trump has sought. So you've got Ambassador Sondland's emerging recollection. But what you've got is actually written notes taken at the time that he does not contest. Written notes of Ambassador Taylor and Mr. Morrison. Notes which I believe will reflect quite clearly the understanding of dirt for dollars that was confirmed by this telephone call with President Trump.
Well, you weren't dissuaded then, right? Because you still thought that the aid was conditioned on the public announcement of the investigations after speaking to President Trump.
By September 8th, I was absolutely convinced it was.
And President Trump did not dissuade you of that in the conversation that you acknowledged you had with him?
I don't ever recall, because that would have changed my entire calculus. If President Trump had told me directly, I'm not...
That's not what I'm asking, Ambassador Sondland. I'm just saying, you still believed that the security assistance was conditioned on the investigation after you spoke to President Trump. Yes or no?
From a time frame standpoint, yes.
Okay, so here we have Sondland saying that whatever his recollection may be about that call, he was still very clear what the President wanted, and he was very clear there was a quid pro quo. That is consistent, obviously, with what Mr. Morrison has had to say and Ambassador Taylor. In other words, he didn't believe President Trump's denial of a quid pro quo, and neither should you. Sondland's understanding was further confirmed by President Trump's own chief of staff. On October 17, at a press briefing in the White House, Mick Mulvaney admitted that President Trump withheld the essential military aid for Ukraine as leverage to pressure Ukraine to investigate the conspiracy theory that Ukraine had interfered in the 2016 election.
So those were the driving factors. Did he also mention to me in the past the corruption related to the DNC server? Absolutely, no question about that. But that's it, and that's why we held up the money.
When pressed that he had just convinced of the very quid pro quo that President Trump had been denying, Mulvaney doubled down. Let's listen to that.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happens as well.
We do that all the time with foreign policy.
This evidence demonstrates that President Trump withheld the security assistance in the White House meeting with President Zelensky until Ukraine made a public statement announcing the two investigations targeted to help his political re-election efforts. But as you will learn next, he got caught, and the cover-up ensued.
Mr. Chief Justice and Senators, thank you for your patience. This is a lot of information, but you have a very important obligation, and that is ultimately to decide whether the President committed impeachable offenses. And in order to make that judgment, you have to have all of the facts. And so we're going through this chronology. We're close to being done. But it's important to know that while all of this material was going on, these deals were being made, there were other forces at work. Even before the President's freeze on U.S. military assistance to Ukraine became public on August 28th, members of both houses of Congress began to express concern. On August 9th, the Democratic leadership of the House and Senate Appropriations Committee wrote to the OMB and the White House warning that a hold on assistance might constitute an illegal impoundment of funds. They urged the Trump administration to follow the law and obligate the funding. When the news of the frozen aid broke on August 28th, congressional scrutiny of President Trump's decision increased. On September 3rd, a group of senators, both Republicans and Democrats, including Senator Jeanne Shaheen, Senator Rob Portman, Senator Dick Durbin, Senator Ron Johnson, Senator Richard Blumenthal, sent a letter to acting White House Chief of Staff Mick Mulvaney expressing, and I quote, deep concerns that the administration is considering not obligating the Ukraine Security Initiative funds for 2019. 2 days later, as has been mentioned, on September 5th, a Washington Post editorial expressed concern that President Trump was withholding military assistance to Ukraine in order to pressure President Zelensky to announce these investigations. That was the first public report linking the frozen security aid to the investigations that Mr. Giuliani had been publicly pressing for, and that President Trump, as we've heard, had privately urged President Zelensky to conduct on the July 25th call. That same day, Senators Murphy and Johnson met with President Zelensky in Kiev. Ambassador Taylor went with them, and he testified, Mr. Taylor testified, that President Zelensky's, quote, first question to the senators was about withheld security assistance. Ambassador Taylor testified that both senators, quote, stressed that bipartisan support for Ukraine and Washington was Ukraine's most important strategic asset, and that President Zelensky should not jeopardize that bipartisan support by getting drawn into U.S. domestic politics. Now, Senator Johnson and Senator Murphy later submitted letters where they explained that they sought to reassure President Zelensky that there was bipartisan support in Congress for providing Ukraine with military assistance, and that they would continue to urge President Trump to lift the hold. Here is what they said in that letter. Senator Murphy said, Senator Johnson and I assured Zelensky that Congress wanted to continue this funding and would press Trump to release it immediately. And Senator Johnson in the letter said, I explained that I'd tried to persuade the president to authorize me to announce the hold was released, but that I was unsuccessful. Now, as news of the president's hold on military assistance to Ukraine became public at the end of August, Congress, the press, the public started to pay more attention to President Trump's activities with Ukraine. This risked exposing the scheme that you've heard so much about today. By now, the White House had learned that the Inspector General of the intelligence community had found that a whistleblower complaint related to the same Ukraine matter was, quote, credible and, quote, an urgent concern, and was therefore, that they were therefore required to send that complaint to Congress. On September 9th, 3 House investigating committees sent a letter to White House counsel Pat Cipollone stating that President Trump and Giuliani, quote, appear to have acted outside legitimate law enforcement and diplomatic channels to coerce the Ukrainian government into pursuing 2 politically motivated investigations under the guise of anti-corruption activity. The letter also said this: if the president is trying to pressure Ukraine into choosing between defending itself from a Russian aggression without U.S. assistance or leveraging its judicial system to serve the ends of the Trump campaign, this would represent a staggering abuse of power, a boon to Moscow, and a betrayal of the public trust. The chairs requested that the White House preserve all relevant records and produce them by September 16th. This included the transcript, or actually the call record, of the July 25th call between President Trump and President Zelensky. Now, based on witness testimony, it looks like the White House counsel's office circulated the committee's document request around the White House. Tim Morrison, a senior director at the National Security Council, remembered seeing a copy of this letter. He also recalled that the 3 committees' Ukraine investigation was discussed at a meeting of senior-level NSC staff soon after it was publicly announced. Lieutenant Colonel Vindman recalled discussions among the NSC staff members that the investigation, and here's a quote, might have the effect of releasing the hold on Ukraine military assistance because it would be, quote, potentially politically challenging for the administration to justify that hold to Congress. Later that same day, on September 9th, the Inspector General informed the House and Senate Intelligence Committees he'd determined that the whistleblower complaint that had been submitted on August 12th appeared to be credible, met the definition of urgent concern under the statute, and yet, he reported, that for the first time ever, the acting director of national intelligence was withholding this whistleblower complaint from Congress. That violated the law, which required him to send it in 7 days. The acting director later testified that his office initially withheld the complaint based on the advice from the White House and an unprecedented intervention by the Department of Justice. Now, according to public reporting and testimony from the acting DNI at a hearing before the House Intelligence Committee on September 26th, the White House had been aware of the whistleblower complaint for weeks prior to the IG's September 9th letter to the intelligence committees. Acting DNI McGuire testified that when he received the whistleblower complaint from the Inspector General, his office contacted the White House counsel's office for guidance. Consistent with acting DNI McGuire's testimony, the New York Times has reported that in late August, the president's current defense counsel, Mr. Cipollone, and NSC lawyer John Eisenberg personally briefed President Trump about the complaint's existence and told the president they believed the complaint could be withheld from Congress on executive privilege grounds. Now, on September 10th, the next day, Ambassador Bolton resigned from his position as National Security Advisor. On that same day, September 10th, Chairman Schiff of the House Intelligence Committee wrote a letter to the acting director demanding that he provide the complaint as the law required. The next day, on September 11th, President Trump lifted the hold on the security assistance to Ukraine. Now, numerous witnesses have testified that they weren't aware of any reason why the hold was lifted, just as there was no explanation for the hold being implemented. There was no additional review, no additional European contribution, Nothing to justify the president's change in position, except he got caught. Just as there was no official explanation for why the hold on Ukrainian assistance was implemented, numerous witnesses testified that they were not provided with any reason for why the hold was lifted on September 11th. For example, Jennifer Williams, who was the special advisor to Vice President Pence, testified that she was never given a reason for that decision. Neither was Lieutenant Colonel Vindman. Here's what he told us during the hearing.
Are you also aware, however, that the security assistance hold was not lifted for another 10 days after this meeting?
That's correct.
And am I correct that you didn't learn the reason why the hold was lifted?
That's correct.
Colonel Vindman, you didn't learn a reason why the hold was lifted either, is that right?
Correct.
Colonel Vindman, are you aware that the committees launched an investigation into Ukraine matters on September 9th, 2 days before the hold was lifted?
I am aware, and I was aware.
Ambassador Taylor, the person in charge at the U.S. Embassy in Kiev, who communicated the decision to the Ukrainians, also never got an explanation. Here's what he said.
Are you also aware, however, that the security assistance hold was not lifted for another 10 days after this?
9th. Finally, on September 11th, I learned that the hold had been lifted and security assistance would be provided. I was not told the reason why the hold had been lifted.
Mark Sandy, a career officer at OMB, testified he only learned of a possible rationale for the hold in early September after the acting DNI had informed the White House about the whistleblower complaint. Now, Sandy testified that sometime in early September, he received an email from his boss, Michael Duffy. Approximately 2 months after the hold had been placed, the email, quote, attributed the hold to the president's concern about other countries not contributing more to Ukraine and requested, quote, information about what additional countries were contributing to Ukraine. This was a different explanation than OMB had provided at the July 26th interagency meeting. That referenced concerns about corruption. Lieutenant Colonel testified that none of the facts on the ground about Ukrainian efforts to combat corruption or other countries' contribution to Ukraine had changed before President Trump lifted the hold. According to a press report, after Congress began investigating President Trump's scheme, the White House counsel's office opened an internal investigation relating to the July 25th call. The following slides provide excerpts from a report in the Washington Post. As part of that internal investigation, White House lawyers reportedly gathered and reviewed hundreds of documents that reveal extensive efforts to generate an after-the-fact justification for the hold on military assistance for Ukraine that had been ordered by the president. These documents reportedly include, quote, early August email exchanges between Acting Chief of Staff Mick Mulvaney and White House budget officials seeking to provide an explanation for withholding the funds after the president had already ordered a hold in mid-July on the nearly $400 million in security assistance. The Washington Post article also reported that, and this is a quote, emails show OMB Director Vaught and OMB staffers arguing that withholding the aid was legal while officials at the National Security Council and State Department protested. OMB lawyers said that it was legal to withhold the aid as long as they deemed it a temporary hold. You should be able to see these documents, but the White House has withheld them from Congress. So the House can't verify the news report, but you could. You could do that if you could see these documents. You should subpoena them, and there's no reason not to see all the relevant documents. Now, the lengthy delay created by President Trump's hold prevented the Department of Defense from spending all congressionally appropriated funds by the end of the fiscal year, as we've mentioned before. That meant the funds were going to expire on September 30th because, as we know, unused funds do not roll over to the next fiscal year. This confirmed the fears expressed by Cooper, Sandy, and others, concerns that were discussed within the relevant agencies in late July and throughout August. Ultimately, $35 million of Ukraine military assistance, that's 14% of the DoD funds, remained unspent by the end of the fiscal year in order to make sure that Ukraine did not permanently lose the $35 million of critical military assistance that had been frozen by the White House. Congress had to pass a provision on September 27th, 3 days before the funds were to expire, to ensure that the remaining $35 million could be sent to Ukraine. Now, George Kent is an anti-corruption and rule of law expert. He told us that American anti-corruption efforts prioritize building institutional capacity, support for the rule of law, not the pursuit of individual investigations, particularly of political rivals. Here's how he explained their approach.
U.S. efforts to counter corruption in Ukraine focus on building institutional capacity so that the Ukrainian government has the ability to go after corruption and effectively investigate, prosecute, and judge alleged criminal activities using appropriate institutional mechanisms. That is, to create and follow the rule of law. That means that if there are criminal nexuses for activity in the United States, U.S. law enforcement should pursue the case. If we think there's been a criminal act overseas that violates U.S. law, we have the institutional mechanisms to address that. It could be through the Justice Department and FBI agents assigned overseas, or through treaty mechanisms, such as the Mutual Legal Assistance Treaty. As a general principle, I do not believe the United States should ask other countries to engage in selective, politically associated investigations or prosecutions against opponents of those in power, because such selective actions undermine the rule of law, regardless of the country.
Now, David Holmes concurred during his testimony. Holmes also compared the official approach that we believe in, that we promulgate across the world, with what the President and Mr. Giuliani actually were doing.
So our long-standing policy is to encourage them to establish and build rule of law institutions that are capable and that are independent and that can actually pursue credible allegations. That's our policy. We've been doing that for quite some time with some success. So focusing on particular cases, including particular cases where there is a interest of the president's, it's just not part of what we've done. It's hard to explain why we would do that.
Unfortunately, we do know the explanation. We know why President Trump wanted President Zelensky to announce investigations, because it would help him in his election. Now, on September 18th, approximately a week before he was supposed to meet with President Trump at the United Nations General Assembly in New York, President Zelensky spoke by telephone with Vice President Pence. During her deposition, Jennifer Williams testified, and she was Vice President Pence's assistant. She testified that Vice President Pence basically reiterated that the hold on aid had been lifted and asked a bit more about how Zelensky's efforts were going. Now, following her deposition and while preparing for her testimony at the open hearing on November 19th, Williams reviewed the documents. They've not been produced to us by the White House, and those documents refreshed her recollection of Vice President Pence's call with President Zelensky. Now, the White House blocked Williams from testifying about her refreshed recollections of the Vice President's call when she appeared at the open public hearing. They claimed that certain portions of the September 18th call, including the information that Williams wanted to tell us about, were classified. On November 26th, she submitted a classified addition to her hearing testimony, where she provided additional information about the Vice President's September 18th telephone call with President Zelensky. The Intelligence Committee provided this classified addition to the Judiciary Committee. It has been sent to the Senate for your review. Now, I've read that testimony. I'll just say that a cover-up is not a proper reason to classify a document. Vice President Pence has repeatedly said publicly that he has no objection to the White House releasing the actual transcript of his calls with President Zelensky, and yet his office has refused many requests by the committee to declassify Williams' addendum so the American people could also see the additional evidence about this call. We urge the senators to review it, and we ask again that the White House declassify it. As the House wrote in 2 separate letters, there is no basis to keep it classified, and again, in case the White House needs a reminder, it's improper to keep something classified just to avoid embarrassment or to conceal wrongdoing. Now, we've been through a lot of facts today. We've seen the president's scheme, a shakedown of Ukraine for his personal benefit, was, I believe, an obvious abuse of his power. But this misconduct, the scheme, became exposed. Congress asked questions. The press reported. Non-political officers in the government expressed concern. The whistleblower laws were activated. As this happened, there was an effort to create an after-the-fact, misleading record to avoid responsibility for what the president had actually been doing. These were not the only efforts to hide misconduct, and the misconduct continued. Congressman Schiff will review some of those items.
So we have about 20 minutes left in the presentation tonight. I'd like to now go through with you the President's efforts to hide this corrupt scheme, even as it continued well into the fall of last year. On August 12th, a whistleblower in the intelligence community submitted a complaint addressed to the Congressional Intelligence Committees. This explosive document stated that President Trump had solicited foreign interference from Ukraine to assist in his 2020 re-election bid. The complaint alleged a scheme by President Trump to, quote, use the power of his office to solicit interference from a foreign country in the 2020 U.S. election. The complaint stated that the president had applied pressure on Ukraine to investigate one of the president's main domestic political rivals and detailed the involvement of the president's personal lawyer, Rudy Giuliani. The complaint also stated that the whistleblower believed that the president's activities, quote, pose risk to U.S. national security and undermine the U.S. government's efforts to deter and counter foreign interference in U.S. elections. Under the law, the whistleblower was required to file the complaint with the Inspector General of the intelligence community, which was then required to vet and assess the complaint and determine if it warranted reporting to the intelligence committees. The law gives the Inspector General 14 days to conduct an initial review and then inform the Director of National Intelligence about his findings. On August 26, the Inspector General sent the whistleblower complaint and the Inspector General's preliminary determination to the Acting Director of National Intelligence. The Inspector General wrote that based on his review of the complaint, its allegations constituted an urgent concern and appeared credible under the statute. The Inspector General confirmed that the whistleblower acted lawfully in bringing the complaint and credibly raised a legitimate concern that should be communicated to the intelligence committees of Congress. The Director of National Intelligence quickly informed the White House about the complaint. Under the law, the acting director of national intelligence was required to forward the complaint and the Inspector General's determination to the Congressional Intelligence Committees no later than 7 days after he received it. The legal requirement is extremely clear. Upon receipt of the transmittal from the ICIG, that is the Inspector General of the Intelligence Community, the director shall, within 7 calendar days of such receipt, forward such transmittal to the Congressional Intelligence Committees together with any comments the director considers appropriate. Yet, despite the clear letter of the law, the White House mobilized to keep the information in the whistleblower complaint from Congress, including by inviting the Department of Justice to render an opinion as to whether the complaint could be withheld from Congress. The statutory deadline of September 2nd, when the Director of National Intelligence was required to turn it over to Congress, came and went, and the complaint remained hidden from Congress. Finally, on September 9th, a full week after the complaint was required to be sent to Congress, and once again, an urgent concern, the Inspector General, 1 week after it was required to be sent to Congress, the Inspector General wrote to the leaders of the intelligence committees to inform them that the Director of National Intelligence was withholding a whistleblower complaint in direct contravention of past practice and the law. On September 24th, Speaker of the House Nancy Pelosi announced that the House of Representatives is moving forward with an official impeachment inquiry. The next day, the House of Representatives passed a resolution calling on the Trump administration to provide the whistleblower's complaint immediately to the Congressional Intelligence Committees. Later that day, the White House publicly released the summary of the July 25th call between President Trump and President Zelensky, and permitted the acting Director of National Intelligence to provide the whistleblower's complaint and related documents to the Congressional Intelligence Committees. The President himself was happy to discuss the motivations for the scheme in public. That day, in a joint press availability with President Zelensky at the United Nations General Assembly, President Trump reiterated that he wanted Ukraine to investigate the Bidens.
To do more on Joe Biden and investigate.
No, I want him to do whatever he can. This was not his fault. He wasn't there. He's just been here recently. But whatever he can do in terms of corruption, because the corruption's massive. Now, when Biden's son walks away with millions of dollars from Ukraine and he knows nothing, and they're paying him millions of dollars, that's corruption.
Finally, the day after President Trump explained to the public that he wanted Ukraine to investigate former Vice President Biden, on the morning of September 26th, the Intelligence Committee publicly released declassified redactions of 2 documents, the whistleblower's August 12th complaint and the Inspector General's August 26th transmittal to the Acting Director of National Intelligence. Even after the impeachment inquiry into the Ukraine matter began, President Trump and his proxy, Rudy Giuliani, have continued to publicly urge President Zelensky to launch an investigation of Vice President Biden and alleged 2016 election interference by Ukraine. On September 30, during his remarks at the swearing-in of the new Labor Secretary, President Trump stated,
Now, the new president of Ukraine ran on the basis of no corruption. That's how he got elected. And I believe that he really means it. But there was a lot of corruption having to do with the 2016 election against us. And we want to get to the bottom of it, and it's very important that we do. Thank you very much.
So here he is, this meeting at the United Nations, September 30, and he's still pursuing this bogus CrowdStrike conspiracy theory with the president of Ukraine. On October 2nd, in a public press availability, President Trump discussed the July 25th call with President Zelensky and stated the conversation was perfect, it couldn't have been nicer. He then linked his notion of corruption with the Biden investigation. On October 3rd, in remarks before he departed on Marine One, President Trump expressed his hope that Ukraine would investigate Vice President Biden and his son. President Trump actually escalated his rhetoric, urging not only Ukraine to investigate the Bidens, but China too.
Mr. President, what exactly did you Biden after your phone call? Exactly.
Well, I would think that if they were honest about it, they'd start a major investigation into the Bidens. It's a very simple answer. They should investigate the Bidens, because how does a company that's newly formed, and all these companies, if you look at, and by the way, likewise, China should start an investigation into the Bidens, because what happened in China is just about as bad as what happened with Ukraine. So I would say that President Zelensky, if it were me, I would recommend that they start an investigation into the Bidens.
The same day, President Trump tweeted that he has an absolute right to investigate corruption. What that really means is he feels he has an absolute right to investigate or get foreign countries to investigate his political opponents. The president sent a similar tweet the next day, once again linking corruption with the Biden investigation. As president, I have an obligation to end corruption, even if that means requesting the help of a foreign country or countries. It is done all the time. This has nothing to do with politics or a political campaign against the Bidens. This does have to do with corruption. Give him credit for being so obvious. This has nothing to do with politics or a political campaign against the Bidens, but you got to investigate the Bidens. I guess that's just a coincidence. President Trump continued to demonstrate his eagerness to solicit foreign assistance related to his personal interest. Here's what's okay. He said, if we feel there's corruption, like I feel there was in the 2016 campaign, there was tremendous corruption against me. If we feel there's corruption, we have a right to go to a foreign country. President Trump added that asking President Xi of China to investigate the Bidens is certainly something we can start thinking about. Even last month, the president and Giuliani's scheme continued. During the first week of December, Giuliani traveled to Budapest, Kyiv, and Vienna to meet with the former Ukrainian government officials as part of a continuing effort to dig up dirt, political dirt, on Vice President Biden and advance the theory that Ukraine interfered in the 2016 election. Asked about his interviews of foreign Ukrainian prosecutors, Giuliani told the New York Times that he was acting on behalf of his client, President Trump. Quote, like a good lawyer, I am gathering evidence to defend my client against the false charges being leveled against him. Indeed, evidence obtained by the House from Giuliani's associate confirms that he had been representing himself in as early as May 2019 as President Trump's personal lawyer, doing Donald J. Trump's personal bidding in his dealings with Ukraine. This letter, May 10th, 2019, from Giuliani to Zelensky, says, among other things, however, I have a more specific request. In my capacity as personal counsel to President Trump and with his knowledge and consent, I request a meeting with you this upcoming Monday, May 13th, or Tuesday, May 14th. I will need no more than a half an hour of your time, and I will be accompanied by my colleague, Victoria Tensing, a distinguished American attorney who is very familiar with this matter. Please have your office let me know what time or times are convenient for you, and Victoria and I will be there. So this is evidence recently obtained showing his effort to get that meeting in May with Zelensky. Giuliani told the Wall Street Journal that when he returned to New York from this most recent trip on December 7th, President Trump called him as his plane was still taxiing down the runway. What did you get? He said, President Trump asked. More than you can imagine, Giuliani replied. Giuliani claimed that he was putting his findings into a 20-page report that the president had asked him to brief the Attorney General and the Republicans in Congress. Shortly thereafter, on the same day, President Trump told reporters before departing on Marine One that he was aware of Giuliani's efforts in Ukraine and that Giuliani was going to report his purported findings to the Attorney General and Congress.
Well, I just know he came back from someplace and he's going to make a report, I think, to the Attorney General and to Congress. He says he has a lot of good information. I have not spoken to him about that information, but Rudy, as you know, has been one of the great crime fighters of the last 50 years. And he did get back from Europe just recently. And I know he has not told me what he's found, but I think he wants to go before Congress and say, and also to the Attorney General and the Department of Justice, I hear he's found plenty. Yeah.
3 days after that, those remarks, on December 10th, Giuliani confirmed to the Washington Post that President Trump had asked him to brief the Justice Department and Republican senators on his, quote, findings, unquote, from his trip to Ukraine. Giuliani stated, "He wants me to do it. I'm working on pulling it together and hope to have it done by the end of the week." That Friday, December 13th, Giuliani reportedly met with President Trump at the White House. And on December 17th, Giuliani confirmed to CNN that President Trump has been very supportive of his efforts to dig up dirt on Vice President Biden in Ukraine and that they are on the same page. The following day, on December 18, 2019, the House of Representatives approved the 2 articles of impeachment you are considering in this trial. Since the House voted on these articles, evidence has continued to come to light related to the President's corrupt scheme. Among other things, Freedom of Information Act lawsuits, press reporting, and documents provided to Congressman Rudy Giuliani, Associate Lev Parnas, further corroborate what we already know about the President's scheme. As Giuliani again said on December 17th, President Trump has been, quote, very supportive, unquote, of his efforts to dig up dirt on Vice President Biden, and they are, quote, on the same page. Parnas further corroborated what we already know about President Trump's scheme, that he was responsible for withholding military aid and sustaining that hold, and that his personal attorney, Mr. Giuliani, was working at the direction of President Trump himself. On December 20th, new emails were released showing that 91 minutes after President Trump's call with the Ukrainian President Zelensky, a top Office of Management and Budget aide asked the Department of Defense to hold off on sending military aid to Ukraine. So those were new documents that came on December 20th. On December 29th, revelations emerged from OMB Director and Acting Chief of Staff Mick Mulvaney's role about that role in the delay of aid, and efforts by lawyers at OMB, the Department of Justice, and the White House to justify the delay and the alarm that the delay caused within the administration. Those records just became available on December 29th. On January 2nd, newly unredacted Pentagon emails which raised serious concerns by Trump administration officials about the legality of the President's hold on aid became available. On January 6th, former Trump National Security Advisor John Bolton announced that he would comply with a Senate subpoena compelling his testimony. His lawyers stated that he has new relevant information. On January 13th, reports emerged that the Russian government hacked the Ukrainian gas company Burisma, almost certainly in an effort to find information about Vice President Joe Biden's son in order to weaponize that information against Mr. Biden and in favor of Mr. Trump, just as Russia did against Secretary Clinton in favor of then-candidate Trump in 2016. That brings us up to January 13th of this year. Last week, House committees received new evidence from Lev Parnas that further demonstrates that the President was a central player in this scheme to pressure Ukraine for his political gain. And also last week, the Government Accountability Office found that President Trump violated the law when he withheld that aid. Last night, we had a further development when more redacted emails from the Office of Management and Budget were produced. I think Representative Crow showed you these. These are among the documents that were just released. I'm sure that if we could read under those redactions, it would be a very perfect email. But you have to ask, what is being redacted here? What is so important to keep confidential during the course of an impeachment inquiry? As you can see, right up until last night, evidence continues to be produced. The truth is going to come out. Indeed, the truth has already come out, but more and more of it will. More emails are going to come out. More witnesses are going to come forward. They're going to have more relevant information to share. And the only question is, do you want to hear it now? Do you want to know the full truth now? Do you want to know just who was in the loop? Sounds like everyone was in the loop. You want to know how broad this scheme was? We have the evidence to prove that President Trump ordered the aid withheld. He did so to coerce Ukraine to help his re-election campaign. He withheld a White House meeting to coerce the same sham investigations. We can and will prove President Trump guilty of this conduct and of obstructing the investigation into his misconduct. But you and the American people should know who else was involved in this scheme. You should want the whole truth to come out. You should want to know about every player in this sordid business. It is within your power to do so. And I would urge you, even if you're prepared to vote to convict and impeach and remove this president, to find out the full truth about how far this corruption goes. Because I think the public has a right to know. Now, yesterday we made the case for why you should hear this additional evidence and testimony. This morning I introduced you to the broad sweep of the president's conduct. And then during the course of today, we walked you through a factual chronology in real time about how this plot unfolded. And during that factual chronology today, you saw that in March of this year, Giuliani began that smear campaign against Ambassador Yovanovitch in order to get her fired by President Trump, something he would later admit was necessary to get her out of the way because she was going to be in the way of these two investigations. This is the supposed anti-corruption effort by the president to get rid of a woman who has dedicated her career to representing the United States, often in dangerous parts of the world, to fighting corruption and to promoting the rule of law. This plot begins with getting her out of the way, with the president saying that she's going to go through some things. This anti-corruption reformer, this U.S. patriot, this plot begins with getting her out of the way. And tellingly, and this says so much about the administration, tellingly, it wasn't enough just to recall her or fire her. The president could have done that any time. No, they wanted to destroy her because she had the audacity to stand in their way. So we heard in March about the effort to get rid of her, and it succeeded. And guess what message that sent to the Ukrainians? About the power the president's lawyer has. The Ukrainians were watching this whole saga. They were hearing his interviews. They were seeing the smears that he was putting out. And this attorney for the president, working hand in hand with these corrupt Ukrainians, was able to get a UN ambassador yanked out of her job. Proof positive. You want a window to this president, you want entree to this president, you want to make things happen with this president, you go through his lawyer. Never mind the State Department, never mind the National Security Council, never mind the Defense Department, you go through his lawyer. That's March. April, Zelensky has this huge victory in the presidential election. He gets a congratulatory call from the president. The president assigns Vice President Pence to go to the inauguration. May, Giuliani is rebuffed by Zelensky. cancels the trip to Ukraine, the one where he wanted to go, remember, meddle in the investigation. Because, Giuliani says, enemies of Trump surround Zelensky. I guess that means he didn't get the meeting and they must be enemies of the president. Of course, the Ukrainians know why he wants that meeting. May, Trump disinvites Pence to the inauguration. Pence is going, Giuliani's rebuffed, Pence ain't going. That's May. Instead, May 23rd, we have this meeting at the White House, and there's a new party in town, the Three Amigos. They're going to be handling the Ukraine portfolio. And they're told, work with Rudy. Work with Rudy. Ambassador Sondland, Ambassador Volker, Secretary Perry. Work with Rudy. And as you saw in June, Giuliani's pushing for these investigations. And they're trying to arrange these meetings and trying to make this happen. And also in June, the Defense Department announces they're going to release the military aid. And the president reads about this. And then he stops it. He stops the aid. In July, on July 10th, you heard in the chronology, there's that meeting at the White House. The meeting in which Sondland blurts out in this meeting between Ukrainians and Americans, hey, they've got a deal. They're trying to get this meeting, and there's a debate about whether the meeting is going to happen and when it's going to happen, and Sondland says, hey, we've got a deal with Mulvaney here. We're going to get this meeting, and you're going to do those investigations. And Bolton stiffens and abruptly ends the meeting. That was the first meeting that day, and then Sondland brings the delegation to a different part of the White House, and they have the follow-up meeting where he makes it even more explicit. This drug deal is made even more explicit. And Dr. Hill is told by Ambassador Bolton, you need to go talk to the lawyers. I don't want any part of this drug deal they're cooking up. That's July. July is the month where that email goes from Sondland to Pompeo and others, and everybody is in the loop. July is the month where the hold is implemented with no explanation. July is the month where Mueller testifies about Russia's systemic interference in our affairs. July is the month after Mueller testifies that the president believes he has escaped accountability. The next day in July is, of course, the July 25th call, in which the president asks for his favor. And July is the month, July 26th is the date of the call between President Trump and Ambassador Sondland. You know the one. Zelensky loves your ass. He'll do anything you want. Is he going to do the investigation? Yeah, he's going to do the investigation. July is the month of that conversation between Sondland and David Holmes, where Holmes says, can you tell me candidly here what the president thinks of Ukraine? Does he give a blank about Ukraine? No, he doesn't give a blank about Ukraine. He only cares about the big stuff. Well, there's kind of big stuff here in Ukraine, like a war with the Russians. No. Big stuff that affects him personally, like the Biden investigation that Giuliani wants. That's the month of July. August, we have that meeting between Giuliani and Yermak in Madrid. August, we have the back and forth about the statement. No, you go first. And you commit and publicly announce the investigations, and then we'll give you a date. No, you go first. You give us the date, and then we'll announce the investigations. Well, we'll give you a statement that doesn't mention the specifics. No, you give us a statement that mentions the investigations. That's the month of August. August is also the month where it becomes clear that it's not just the meeting anymore. It's everything. Everything is conditioned on these investigations. The relationship, the money, the meeting. Sondland and Holmes testify it's as simple as 2 + 2 = 4. That's August. September, Sondland says to Yermak, everything is conditioned on public announcements. So Message delivered, no ambiguity. The Ukrainians are told quid pro quo. Taylor texts, this is crazy, to withhold aid. September's the month, September 7th in particular, Trump and Sondland talk on the phone, and the president has that conversation where he says, no quid pro quo, except here's the quid pro quo. Zelensky's got to go to the mic, and what's more, he should want to do it. September is also the month where the investigations begin in Congress. September's the month where after those investigations begin, after the president knows he's been caught, the aid is finally released. And September is the month where Pence and Zelensky are on the phone, and Jennifer Williams has classified information to share with you that I hope you will take a look at because it is relevant to these issues. That's September. October, Trump admits, yes, if it wasn't obvious enough, he wants Ukraine to investigate his political opponent. October is the month where he invites another nation, China, to investigate his opponent. This is the broad outline of the chronology that we went through today. Tomorrow, we will go through the law, the Constitution, and the facts as they apply to Article 1. That is the plan for tomorrow. We've introduced the case, we've gone through the chronology, and tomorrow we will apply the facts to the law as it pertains to the President's abuse of power. And let me just conclude this evening by remarking again on what brought us here. What brought us here is that some courageous people came forward. Courageous people that risked their entire careers. And one of the things that's been so striking to me about that as I watch these witnesses like Maria Yovanovitch and Ambassador Taylor and David Holmes and others, Dr. Hill, is how much these dedicated officials were willing to risk their career, the beginning of their career, or the middle of their career, or late in their career, when they had everything to lose. But people senior to them who have every advantage, who sit in positions of power, lack that same basic commitment, lack that same basic willingness to put their country first and expose wrongdoing. Why is it that Colonel Vindman, who worked for Fiona Hill, who worked for John Bolton and Dr. Kupperman, why is it that they were willing to stick their neck out and answer lawful subpoenas when their bosses wouldn't? I don't know that I can answer that question, but I just can tell you I have such admiration for the fact they did. I think, and I think this is some form of cosmic justice, that this ambassador that was so ruthlessly smeared is now a hero for her courage. There is justice in that. But what will really vindicate that leap of faith that she took is if we show the same courage. They risked everything, their careers. And yes, I know what you're asked to decide may risk yours too. But if they could show the courage, so can we. I yield back.
I'm sorry, sir.
Pursuant to the provisions of Senate Resolution 243 of the 100th Congress, a single one-page classified document identified by the House managers for filing with the Secretary of the Senate that will be received on January 22, 2020, shall not be made part of the public record and shall not be printed, but shall be made available pursuant to the standing order from the 100th Congress. The Majority Leader is recognized.
Mr. Chief Justice, colleagues, we're almost through for the evening. We'll convene again at 1 o'clock tomorrow. Before we adjourn, I'd like to acknowledge that tomorrow is the official last day for this term's Senate pages. This group of in addition to witnessing this unusual event that we're all experiencing, they're studying for their final exams as well, and we wish them well as they head off back to boring normal high school.
Mr. Leader, let me just add my thanks and gratitude for all of us. It is rare, particularly these days, when 100 senators from both sides of the aisle of every political persuasion get up and give someone a standing ovation. But you deserve it. Thank you for your good work, and we hope you have beautiful and successful lives.
So, Mr. Chief Justice, I ask unanimous consent that on Tuesday, January the 28th, from 10 a.m. to 11 a.m., while the Senate is sitting as a court of impeachment, and that notwithstanding the Senate's adjournment, the Senate can receive House messages and executive matters, committees be authorized to report legislation and executive matters, and senators be allowed to submit statements for the record, bills, resolutions, and co-sponsor requests, and where applicable, the Secretary of the Senate, on behalf of the presiding officer, be permitted to refer such matters.
Without objection, so ordered.
Finally, I ask unanimous consent that trial adjourn until 1 p.m. Thursday, January 23rd, and this also constitute the adjournment of the Senate.
Without objection, so ordered. Senate is adjourned.